All right, hi, welcome back, Attorney Steve Vondran. Welcome to another exciting episode of Litigation Whiteboard. All right, Saturday edition. Today we are talking about options when you are sued. What do? You get the lawsuit in the mail. Geez, what do you do now? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, here we go. Okay, there's a lot of different options when you get served a lawsuit. It's certainly no fun. You could be sued in federal court for a federal question or a diversity case where you have citizens of two different states or companies of two different states. But let's take a look at some of your general options here. As you can see, let me know if you think I missed one, by the way. Number one, you might have a case that has to be removed. Maybe somebody's suing you for federal discrimination or federal copyright. Somehow they sued you in the state court. Well, you can't do that, at least with the copyright case, that is. So you might want to remove that to federal court. Okay, that's one thing. You see a lot of bigger companies doing this. A lot of Fortune 500 companies will remove their cases. All right, another one. You'd say, well, I'm in federal court, I got 21 days to respond. I'm in state court, maybe I have 30. Check your local rules. You may ask for more time. Call up the other attorney or the other party. Hey, I just got this. I'm going to need some time. Another option is to simply request a short extension, or maybe a 14 or 30-day extension or more, whatever you may need, okay? Requesting more time is certainly an option. Another question I always get is, well, when is a good time to settle your case, Attorney Steve? When is the best time? Best time is any time. You also have a chance right here to settle if you like. Call up the other party, say, geez, I didn't know you were going to sue me. I was kind of testing you. I was kind of playing chicken. All right, you sued me. Let's settle. I don't want to go through the litigation process. It's expensive. It's time consuming, distracting to me, my family, my business. So settling is always an option. Okay, so take a look at that if you like. Next, you can do nothing. You can say, I don't care about any of this. Let them get a judgment. I could care less. We call that a default. So what happens if you do not answer the complaint on time, the other party will default you, okay? Sometimes it's a two-step process where you get the default and then you have to go get the default judgment. You have to prove up your cases. The judge may set a prove-up hearing where you have to prove your damages, okay? And I have down here BK. Another option is bankruptcy. You say, well, I'm going to go see a bankruptcy attorney. I have lots of bills. I have $50,000 in credit card debt. I owe this guy $100,000. This guy wants $250,000 in a lawsuit. I am going to go file bankruptcy. A bankruptcy will stay the proceeding, meaning the court has no authorization to move forward because you're in federal bankruptcy. You're in a stay. This case must be paused. Okay, so if you're not sure about bankruptcy, I always say go to your state bar, check with a state bar specialist. To me, bankruptcy is a kind of a tricky little area. To me, for my money, I want a specialist. All right, default bankruptcy. Next, you may look at the complaint and say there is no merit to this lawsuit whatsoever. So you may look at filing what we call a motion to dismiss. In federal court, we call that a motion to dismiss. Look at your 12B grounds to file. I have a video on that. I'll put it down in the description area below. You may file a motion to dismiss. State court may be called a demur. So check your rules, check your timing, see what the obligations are when you file these types of documents, but you challenge the pleading. Another one is an anti-SLAPP. Somebody sues you for defamation, you're exercising your right of free speech, or petition the government. Anti-SLAPP is another possibility at this level, okay? Finally, you have answer and affirmative defenses. You can say, I'm going to defend this. I am not the breaching party. They're the breaching party. And you can go duke it out in court, file an answer disputing the allegations, and don't forget your affirmative defenses. General rule, raise them or waive them. Raise or waive, okay? Finally, I guess this was actually finally, you can file a countersuit. Okay, you can sue the plaintiff back. You can become the counter plaintiff, counter claimant, okay? That's another option. You can also file against a cross-claim against other parties who may be liable. Maybe somebody agreed to indemnify you. You could bring them into the case. So you can bring a third party into the case. Maybe God forbid, some kid died in your pool. He crept through the gate that you had there. The bars were too wide. Kid sneaks in there. You're being sued by the parents for a wrongful death, and you might need to bring in the company that built the fence and say, Why didn't you build it tighter? That's like crazy. So things like that. Those are your general options, folks, when you get sued. Again, it's no fun. There may be some other options. If you find one that I don't have up here, put it down below. Yelling and screaming is not an option either. So anyway, guys, this is general legal information only. Check your local rules again, but I wanted you to be aware, lots of different options when you're served that summons and complaint. Okay? Don't forget to like, subscribe, and drop your comments below. I try to get to as many as I can, but I appreciate you all watching. Have a great Saturday. Attorney Steve out. Bye now.